Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Be ready. Start. Directing the state to pay market value compensation to a nonagenarian tribal under the Land Acquisition Act 1894, the Himachal Pradesh High Court has said that the State Forest Department cannot deprive him of compensation just because he did not keep copies of the complaints he filed in the past against the Forest Department's illegal use of his land. Stop para. The petitioner, being an innocent tribal aged 94 years, probably did not retain the representations given by him in the past opposing use of this land by the Forest Department, but the Forest Department cannot take advantage of the same, particularly when the issue is being agitated according to the petitioner from the time such construction was made on his land and when at his instance a demarcation was done on 26 to 2009. Stop para. The court was hearing a writ petition challenging the Forest Department's action of acquiring notor land wasteland outside protected areas that government can use clause at Kinnaur district's Akpa village. Stop. Petitioner claimed that he was granted notor traditional land rights clause land in 1955, part of which the Forest Department encroached upon during the construction of officers' quarters. Stop para. The state contested the claim, stating that the petitioner did not cultivate the land within the required time frame and that he never objected to the construction by the Forest Department. Stop para. Adjudicating upon the matter, the bench noted that the grant of notor traditional land rights clause was based on the notor rules and due to the unavailability of old revenue records, there was a lack of evidence to prove that the petitioner had given consent to the Forest Department for utilizing his land. Stop para. In the absence of any material to show that the land was resumed by the government on the ground of non-cultivation of the same, it has to be held that the Forest Department acted illegally, arbitrarily, and in violation of Article 14 and 300A of the Constitution of India in utilizing the land given to the petitioner without paying any market value compensation for the same. The bench added. Stop para. Emphasizing that even though the right to property is not a fundamental right, the court said that it is protected under Article 300A of the Constitution of India. Stop. The government has the power to acquire private property for public purposes but must provide just compensation to the affected individuals. However, in this case, since no compensation was paid to Lal, the Forest Department's actions are deemed unconstitutional. The bench maintained. Stop para. Having regard to the fact that the said extent of land had already been put to use by the state and restoring the said land to the petitioner may not be appropriate in public interest, the court directed the respondents to pay market value compensation to the petitioner under the Land Acquisition Act 1894, treating the land as having been acquired by the state on 1/1/1993. Stop para. The state has also been directed to pay costs of rupees 10,000 to the petitioner within 4 weeks. Stop.